where litigation divides, mediation unites. Good morning and namaskar. I, Dr. Bhagyalakshmi Ratha, Registrar General of Odisha High Court, with utmost humility and respect, now seek the kind permission of Your Lordship, Honorable the Chief Justice, to formally declare the function open. Thank you, Lordship. The proceeding is declared open. It is my privilege to extend my respectful and warm welcome to the Honorable Chief Justice and the Patron-in-Chief of the Odisha State Legal Services Authority, Honorable Executive Chairman, Odisha State Legal Services Authority, Honorable Chairperson, High Court Legal Services Committee, and Honorable Companion Judges of the High Court of Odisha present on this occasion. I also extend a cordial welcome to the Director, Odisha Judicial Academy, the Principal Secretary to Government of Odisha Law Department, the Member Secretary, Odisha State Legal Services Authority, the Secretaries of the District Legal Services Authorities across the state, the panel lawyers and the paralegal volunteers joining us physically and virtually, the nodal officers of the different departments of the state, law students and other distinguished participants. The initiative of Honorable Supreme Court, SAMADHAN Samaroh, reflects our collective commitment to promote mediation as an effective, accessible and human method of dispute resolution, particularly in cases involving government. By encouraging amicable settlements, we not only reduce the burden of the courts, but also foster trust and cooperation between the state and its citizens. The success of Samadhan Samaroh depends greatly on awareness and participation. Programs like this play a vital role in sensitizing stakeholders and spreading the message among the general public that the dispute can be resolved efficiently through dialogue and mutual understanding. May I now request Honorable Sri Justice Krishnaram Mahapatra, Judge, High Court of Odisha, and the Chairperson, High Court Legal Services Committee, to kindly address the gathering. My Lord, please.
Thank you, Registrar General. Namaskar and a very good morning to everybody who are present in this hall as well as joined us virtually and watching this program. This program is being arranged as a part of sensitization and deliberation for achieving the best result in Samadhan Samaroh 2026, a special Lok Adalat which is being organized by Honorable Supreme Court. Honorable Sri Harish Tandon, the Chief Justice of High Court of Odisha and Patron-in-Chief State Legal Services Authority Odisha, OSAL sir. Honorable Sri Manas Ranjan Pathak, Judge High Court of Odisha and Executive Chairman OSAL sir. My sister and brother judges present here. Dr. Bhagyalakshmi Rath, esteemed Registrar General and other officers of the Registry of the High Court of Odisha. Dr. Pavitra Mohan Samal, Principal Secretary, Department of Law, Government of Odisha. Mr. Arvinda Patnaik, esteemed member, Member Secretary and other officers as well as support staff of OSAL sir. Sri Bidut Kumar Mishra, esteemed Director, Odisha Judicial Academy and his team. Sri Satyabrata Mishra, esteemed Coordinator, Arbitration Center, High Court of Odisha. Mr. Pranav Kumar Patra, LR Special Secretary, Department of Law, Government of Odisha, as well as nodal officer, and other esteemed nodal officers of the state government. Learned secretaries of the District Legal Services Authority of different districts, panel lawyers, legal aid defense counsel and PLVs of all the districts of state. All the stakeholders of Samadhan Samaroh 2026, my dear students of different law colleges and universities, members of print and electronic media, officer and staff of Doordarshan Odisha, ladies and gentlemen, I welcome you all to this special sensitization program organized by OSAL, sir. Samadhan Samaroh 2026 is a special Lok Adalat organized by Honorable Supreme Court of India to facilitate and assist the parties to resolve their disputes pending before Honorable Supreme Court through mutually accepted settlement. Honorable Supreme Court also prepared a SOP for seamless and effective settlement of disputes in the Samadhan Samaroh 2026. It aims at participative justice and doorstep delivery of justice, which indicate revolutionary institutional initiative by Honorable Supreme Court making a shift from adversarial litigation to collaborative mediation. It has three distinct stages such as preliminary, onboarding and final stage. We all are aware that Samadhan Samaroh 2026 commenced on 21st April 2026. The special Lok Adalat will be held at Supreme Court of India on 21st, 22nd and 23rd of August 2026. I am informed that 1,719 cases have been identified for Samadhan Samaroh from Odisha, out of which 1,556 cases where the government of Odisha is a party. The identified cases includes civil disputes, matrimonial disputes, motor accident claims, check bounce cases, land acquisition cases, transfer petitions, compoundable criminal cases and financial disputes, etc. We are at present in the onboarding stage of the Samadhan Samaroh, which include the publication of event, meeting of the stakeholders, monitoring pre-Lok Adalat sittings by DLSs and compilation of settlement agreements. State government and public sector undertaking being the major stakeholders, they have a pivotal role to play for successful settlement of disputes. I take this occasion as an opportunity to request all the nodal officers of different departments of the state government to extend their full cooperation for maximum disposal of cases in Samadhan Samaroh. Likewise, the DLSs are also playing a key role in achieving the object of Samadhan Samaroh. We are always available to clear their doubts, confusion, if any, in discharging their duties as per the SOP. It is heartening to note that that our DLSs are thriving hard, and in some cases, remarkable progress has been done. We are hopeful of arriving at settlement in good number of cases identified by Honorable Supreme Court. If any party is desirous of resolving the dispute pending before Honorable Supreme Court, whose case has not been identified, he can still register his case in Samadhan Samaroh, and the DLSs are there to assist them in that regard. I request all the stakeholders to exhibit positive attitude in arriving at settlement. I thank the organizer for giving me this opportunity to share my feelings on this topic. Thank you all. Namaskar. Bande Utkala Janani.
Thank you, Lordship, for such insightful address and guiding us on the importance of mediation and coordinated efforts in resolving pending cases through strengthening mediation mechanism and enhancing access to justice. May I now request Honorable Sri Justice Manas Ranjan Pathak, Judge High Court of Odisha and the Executive Chairperson of Odisha State Legal Services Authority to kindly address the participants. My Lord, please.
Honorable Sri Justice Harish Tandonji, Chief Justice of our Odisha High Court, my brother Justice Krishnaram Mahapatra, Judge High Court of Odisha and Chairman of Odisha High Court Legal Services Committee, my sister and brother judges of the High Court of Odisha who are present here, Dr. Bhagyalakshmi Rathod, Registrar General and her entire team, the Registry of the High Court of Odisha, Learned Director of Odisha Judicial Academy and his entire team, Learned District Legal Services Authority Secretaries of the districts of Cuttack, Puri, Jagatsinghpur, Anagul and Henkal districts who are present here, Learned Principal Secretaries and Nodal Officers of different government departments of the state of Odisha, Learned Registrars and Principals of Premier Law Institutions of the state of Odisha, dear law students of different law institutions of Cuttack and Bhubaneswar who are present here today, Learned Secretaries of District Legal Services Authority, panel lawyers, legal aid defense counsels, paralegal volunteers of all the districts of Odisha who have joined us virtually, other stakeholders, ladies and gentlemen who have joined us virtually from across the state. Namaskar and a very good morning to all of you. Honorable Supreme Court, after due deliberation, decided to take action for immediate adjudication towards harmonization across the nation on 21st, 22nd and 23rd August 2026 at the Supreme Court of India, New Delhi, naming it as SAMADHAN SAMAROH-2026, a special Lok Adalat of Honorable Supreme Court of India with an intention to assist parties in resolving their cases through mutually accepted settlement and reinforces judiciary's commitment to the accessibility in timely delivery of justice. We have seen that litigation is expensive and time-consuming. The Honorable Supreme Court of India have decided said SAMADHAN SAMAROH 2026 with a purpose to provide an environment so as to provide relief to the litigants suffering from long-run litigation, encouraging participative justice. Such Samaroh shall be held by the concerned stakeholders with consultations, meetings with government department, public sector units, the respective parties, insurance companies, central authorities of the Central Board of Direct Taxes and CBIT, and with the judges of monitoring committee having pre-sittings with the district legal services authorities and the parties with their counsels after collecting the data from the district level services authorities on cases where these parties have expressed their willingness to settle through Lok Adalat, and in cases where parties have shown their willingness to proceed towards such solution of their disputes or have reached a final settlement agreement, and after preparation of the draft settlement deeds between the parties to be prepared by the DLSs, those shall be countersigned by the secretaries of DLSs, and such deeds between the parties shall be forwarded to the Honorable Supreme Court. After the SAMADHAN SAMAROH, it shall be placed before the concerned judicial sections for procedural record keeping on 21st, 22nd and 23rd of August 2026. Honorable Supreme Court thereafter shall constitute Lok Adalat benches at Supreme Court, providing VC facilities to the litigants and parties holding the said SAMADHAN SAMAROH 2026 as special Lok Adalat. In the state of Odisha, as my brother have already said, the Honorable Supreme Court has identified 1,719 numbers of pending cases in the first phase, consisting of matrimonial disputes, Sikh bumps cases, criminal compoundable cases, accident claim cases, land acquisition disputes, labor law disputes, and other cases that are suitable for mutual agreement and settlement pending before the Honorable Supreme Court of India. Out of those 1,719 numbers of pending cases, 1,556 number of cases where the state of Odisha itself is one of the parties. The responsibility of the publicity of Samadhan Samaroh 2026 has been based upon the Odisha State Legal Services Authority Cuttack. Amongst other modes of publicity, the Odisha State Legal Service Authority, with due approval of the Patron-in-Chief, our Honorable Chief Justice, have decided to have this sensitization program today for the Samadhan Samaroh 2026. In Odisha Judicial Academic Act, in the Odisha Judicial Academic Cuttack, the process of publicity for special locus adalat at Honorable Supreme Court of India, namely Samadhan Samaroh 26, in Odisha are as follows. The concerned DLSA will be issuing notices to the parties identified for such solution at first. Thereafter, it shall obtain consent from the parties in the respective consent form. Consenting parties thereafter shall appear at district mediation centers on fixed dates for pre-lok adalat sittings. Pre-lok adalat sittings shall be presided by trained mediators and officials of legal services authorities. In successful recording on settlement format, it will be compiled by the concerned DLSs and will be sent to the Honorable Supreme Court of India. And thereafter, listing of successful matters before the Lok Adalat bench of the Honorable Supreme Court of India shall be placed for final disposal. Honorable Supreme Court of India have specifically pointed out that the parties whose cases are not identified in this first phase amongst 1,119 cases can also register in the special website. In addition to that, parties having such disputes before the Honorable Supreme Court can join the special Lok Adalat at any stage, either physically or virtually. In the state of Odisha, as per the rules, all the law colleges have their student legal literacy clubs. Dear students, through such literacy clubs, you can assist the Odisha State Legal Services Authorities as well as the Honorable Supreme Court for publicity of Samadhan Samaroh 2026. We normally know Samadhan as solution in English, but in Sanskrit, as we know, A plus A is equal to A. The word Samadhan means solution in English version, but meaning of Samadhan is to settle or to make a process to settle the long pending disputes through a proper process. Sama means equal and dhan means holding something. As we say that Mr. X is wearing a white shirt, in Odia it is Mr. X is wearing or paridhanam a white shirt or a vastra. After understanding the reasons of disputes between the parties and proper discussions, process is to be find out an alternate way for settlement of such long disputes. Samaroh we know as festival or a program, just like recently celebrated Raja festival, or like Puraskar Samaroh or award ceremony, Dikhanta Samaroh for just like convocation. But the meaning of Samaroh in the present case is to have a ceremonial program following a process for a good cause after due deliberation. From the epic of Mahabharata, we know that Lord Krishna was the first mediator who on behalf of Pandavas went to the Kauravas for settlement of their disputes between them, asking the Kauravas to share a little part of their land for the Pandavas. But the good sense did not prevail on Kauravas, who refused to share even a small part of their land to the Pandavas. And finally, the famous Mahabharata Yuddha occurred, and the result that we know, neither the Kauravas nor the Pandavas could continue to rule over their land at the time of their lifetime. For the purpose of such settlement, the parties whose cases are pending since long must come to with good senses prevailing upon them to have an agreement between the parties after due deliberation during the pre-Lok Adalat sittings as advised by the Honorable Supreme Court with the help of the trained mediators and officials of the legal service authorities. If the parties still continues with the same kind of mindset and want to continue with the litigation, there will be no samadhan between them, probably during their lifetime or thereafter. As such, parties must show their willingness for samadhan for such long pending litigation, which are pending before the Honorable Supreme Court for a long period, for which the Honorable Supreme Court have decided to have the special Lok Adalat 2026, namely the SAMADHAN SAMAROH. It is a responsibility of dear students and all concerned stakeholders to make understand the litigants to settle their disputes through a due process of adequate discussions in presence of all the stakeholders. Mediation, as we all know, is a recognized and alternate dispute resolution system. Thank you and namaskar to all.
Thank you, my lord, for such enlightening words which focused on the Supreme Court pending matters, role of district legal services authorities as mediation centers, and the necessity for coordination between the stakeholders. It is now my proud privilege to invite Honorable Mr. Justice Harish Tandon, the Chief Justice, High Court of Odisha, and Patron-in-Chief of the Odisha State Legal Services Authority, to deliver the keynote address on SAMADHAN SAMAROH 2026 in the backdrop of alternative dispute resolution. My lord, please.
Thank you, Madam. The Honorable Executive Chairman of the Odisha State Legal Services Authority, Justice Manas Ranjan Bhatak, the Honorable Chairperson of the High Court Legal Services Committee, Justice K.R. Mahapatra, my brother and sister judges who are present in this occasion, the Director of the Odisha Judicial Academy, the Principal Secretary to the Government of Odisha, Law Department, Member Secretary, Odisha State Legal Services Authority, Secretaries of all DLSAs, the panel lawyers, paralegal volunteers, joining both physically and on a virtual mode, the nodal officers appointed by the Government of Odisha representing the different departments of the state, my law students who had an occasion to participate in this occasion, and I consider them as a very important resources in shaping the law in future. The print and electronic media, distinguished participants, ladies and gentlemen, a very good morning to all of you. The concept of mediation, as we all know, though deeply rooted and ingrained in the Indian culture, duly recognized and practiced effectively, where the peoples of the society, with their voluntary participation and taking aid of a facilitator, resolve the disputes in a peaceful manner, which in effect percolate a sense of peace and harmony in a civilized society. There has been a gradual shift by passage of time on introduction of the adversarial adjudicatory system, which is regulated and guided by the procedures and the rule of evidence. The empirical data is testament to the explosion of the dockets of our courts of the country and the time consumed in adjudicating the disputes arose between the parties. Alternative dispute resolution mechanism assumes importance not only in reducing the burden of the courts, but providing a structured mechanism or the forum where the parties can amicably resolve the disputes without facing the rigor of the procedural law which regulates the legal proceedings in the courts of the country. The mediation is one of the important facets of the alternative dispute resolution, reinforcing consensual and participatory modes in resolving the disputes. It is cost-effective, participatory, and voluntary, embracing the party autonomy system. By passage of time, it was felt not only to recognize the concept of the mediation as a component of the alternative dispute resolution, but to effectuate such notions and give impetus to the same, and to provide recognition. The first significant step was taken by the Parliament in restructuring Section 89 of the Codicil Procedure. It gained momentum through judicial pronouncements and assumed a great importance within the legal framework. The Apex Court in Salem Advocates Bar Association versus Union of India, reported in 2005, Volume 6, SSC, page 344, upheld the constitutional validity of Section 89 and recognized the avowed object and the purpose underlying such incorporation in the said section, and suggested for providing a legal framework to regulate the alternative dispute resolution processes, which includes mediation. A further significant step can be perceived from another judgment of the Supreme Court delivered in case of Afcon Infrastructure Limited versus Charian Warke Constructions Company Private Limited, reported in 2010, Volume 8, SSC, page 24, defining and categorizing the dispute which comes within the folds of the mediation by reaffirming the legislative aspiration. Thus, the mediation has evolved not only through a legal provision, but also through judicial initiatives. Another significant step to strengthen the mediation as one of the effective tools within the ADR mechanism is by enacting a Mediation Act 2023. The said act not only promotes the mediation, but gives recognition to the party autonomy and the settlement arrived in fair, transparent, and voluntary participation of the parties. The doctrinal values thus engulf the mediation as important, significant, and an integral part of the Indian dispute landscape to work within the structured framework as supplementary to an adjudicatory system without disturbing the core fabric of the adversarial adjudicatory system, and in such a way it cannot be perceived to supplant the same. The eminent mediator, Joseph Greenbaum, observed that an ounce of a mediation is worth a pound of arbitration, and a ton of litigation. Though the ADR mechanism have a variety of the components like an arbitration, mediation, lok adalat, and negotiation, yet the judicial scholars in their wisdom gained from the experience and the empirical data suggested to integrate those components to strengthen the ADR system and opined that even in case of an arbitration, being one of the component of the ADR, the mediation can also play a significant role, and that is how the concept of med-arb evolved. To give a further impetus to the mediation, a significant step has now been taken by the Supreme Court of India in organizing a special Lok Adalat as Samadhan Samaroh. The word Samadhan is not to be understood in a generic sense, but given such name, which conveys a laudable message from the expression, and the Supreme Court has coined this word Samadhan from the Supreme Court action from mediated adjudication and disputes harmonization across nation. That is what the Samadhan has come. The Honorable Chief Justice of India, being pioneer of such initiatives, have envisioned to create a synergy between a mediation and a Lok Adalat. Both being the integral part of the ADR system, yet wanted to integrate like a med-arb to a med Lok Adalat. The concept of this Samadhan Samaroh was actually envisioned by the Honorable the Chief Justice of India way back in the month of April 2026, where the cases which are pending in the Supreme Court of India concerning our state, the figure has already been said by Justice Pathak. The Supreme Court wanted that there are certain litigations which are amenable, or there is a possibility of a settlement through a mediation, and to give some kind of a legal recognition, the Lok Adalat was also thought of to be organized so that it will have a sanctity of a legal bindingness. As we all know that the mediation is a party-centric, where the parties who are there take a control of the entire proceedings with the help and aid of a facilitator whom we commonly know as the mediator. The mediator really acts as a catalyst between the parties to open up the dialogue, to say what their right which they have in relation to such disputes, and what could be the amicable solutions which could be found out so that such dispute can be set at rest in a more peaceful manner. The mediation not only brings an end to a dispute, but the most significant part of the mediation is that it fosters the peace and the harmony between the parties. As we all know, that the moment the dispute cropped up, the first and foremost thing which happened to a parties, that they do not interact with each other, and there is a complete stubbornness in them. The role of the mediator assumes importance as he facilitates the parties to open the dialogue. The moment the parties interact with each other, there are many things that would come out. And therefore, there is every possibility that the disputes which is there for so many years may be brought to its logical end through an amicable mechanism. The mediation, as we all know, is not a origin of a recent time. The Indian cultures have been embracing it since the ages. One of the illustrations was given by Justice Cuttack regarding the Mahabharata, where the Lord Krishna played a role of a mediator and wanted to resolve the disputes. There cannot be any growing apprehension in the minds of a people that once they come for a mediation, they would suffer. It is they who controls. And if they think that there is no possibility of solutions to be arrived, there is no compulsion to continue. They can simply walk out from the mediations. It is one of the mechanisms by which the parties can explore the possibility of amicable solutions, which is definitely within their competence, and therefore the parties should not shy away from interacting with each other and put themselves into a mediation. We all know that there are a lot of litigations which are pending in the docket of the court, including the Supreme Court, which involves the government or its departments. The Honorable Chief Justice of India has for the first time taken up an initiative in structuring this Samadhan Samaroh in such a robust manner where all the departments of the governments were requested to appoint a nodal officer so that any dispute relatable to their department, they would be in a position to negotiate, they would be in a position to find out a solution, they would be in a position to put end to a litigations which is pending for years together. All the nodal officers, as I am told, are physically present here. My request to all of them that please participate with an open heart. Do not carry any kind of an inhibitions. Do not carry any kind of obstructions. If you can resolve the disputes, I think this will be the best service which a person can give to the society. The Supreme Court have also appointed a committee consisting of 5 honorable judges who will be adorning the bench of the Special Lok Adalat that would be organized on 23rd, 24th and 25th of the August. They have also set up a coordination committee of the registrars of the Supreme Court, and they have also provided the forum where the parties can definitely apply and show their willingness to participate in the mediation process. This is the first time that the mediation is been considered along with the Lok Adalat. We should embrace this notion and do not think that it is simply an idle exercise or would remain a dead letter. I think all the government departments, the nodal officers, and all the litigants whose cases are pending in the Supreme Court would definitely they show a cooperation so that this mediation process or the mechanism which has been adopted by the Supreme Court in this regard becomes a successful. I congratulate once again to the government for appointing the nodal officers who will definitely play a very important role in the success of the mediation. You also know, so far as the mediation is concerned, the Honorable Chief Justice of India is now visiting the United Kingdom recently, and the Indian High Commission on 10th of June organized a program where the Honorable Chief Justice of India very aptly conveyed our nation's commitment towards the mediation and sensitization and the widespread publicity which have been made to make this mediation a very successful tool in these words, and I quote, I can say proudly that in India, in every street, in every town, in every village, people talk about mediation, people understand mediation, and people prefer mediations. Thank you all for participating.
Thank you, Lordship, for sharing the vision on alternative dispute resolution and ensuring effective justice delivery. His Lordship's on reducing government litigation, creating public awareness, and the benefits of mediation through sharing his valuable experiences. His Lordship's address has also added value to the program in the sense that true justice lies not only in adjudication but in resolution that restores harmony. We shall now proceed to the interactive session where participants joined us physically and virtually may share their views, experiences, and practical challenges in mediation in terms of identifying suitable cases, counseling, active role of the district authorities, the nodal officers, their accountability, and the monitoring system, and moreover, the coordination among all the departments with their stakeholders. May I now invite Mr. Pavitra Mohan Samal, the Principal Secretary to the Government of Odisha Law Department, Mr. Aravinda Patnaik, the Member Secretary, Odisha State Legal Services Authority, Mr. Satyabrata Mishra, the Member Secretary, High Court Legal Services Committee, to take their seats on the dais. Now the session is open for interaction. Ms. Tanaya Nanda, first year student, second semester, PG Department of Law, Utkal University. Yes.
Good morning. My question today is, as parties are allowed to participate physically as well as virtually in the SAMAROH-2026, how does the judiciary plans on ensuring that rural or unrepresented litigants aren't left behind due to the existing digital divide?
The question is that how they will represent themselves. There are one correction which I wanted to make is that this Samadhan Samaroh is really in relation to matters which are pending before the Supreme Court. So first thing is they must be represented by their lawyer and their participation is also there. So far as the virtual appearance is concerned, I believe that we have already set up the infrastructure in this regard at the taluka level or at the level where they are residing, so that they can virtually attend at the time of the special Lok Adalat. And even at the remote points, if they are unable to come to main places or the Sada, still we have done and put those infrastructures. So there cannot be any apprehension in the mind that they will be denied of their virtual appearances in course of that particular proceedings. And second thing is that so far as the mediation is concerned, it does not really prohibits any lawyer to appear. Rather, it encourages that lawyer should also be there along with the parties, so to take care of their best interests. Yes.
Yes. The next question is from Srimoy Mahapatra, the fourth year student, 7th semester, University Law College, Utkal University.
Good afternoon to the esteemed members of the bench. I am Srimay Mahapatra from University Law College, Utkal University. So my question is, since ADR aims to encourage open dialogue and voluntary participation, do you believe that the increased use of regional language can help parties to communicate more freely, thereby strengthen the effectiveness of mediation and other ADR process?
There is no difficulty, madam. I think the local languages or the regional languages would be the best to communicate, because the party may be more confident in sharing their experiences or percolating their problems. So in that event, I do not find any kind of a obstacle in this regard why the regional or the local languages will not be embraced. Rather, it should be more encouraged so that the parties can openly share what is passing through their mind to have the amicable solutions of this. And I do not think that there is any kind of a restrictions which have been put anywhere that it cannot be done in a local languages. Even I can speak in Hindi and say that कहीं पे भी कोई ऐसा ऑब्स्ट्रक्शंस नहीं है जिसके अंदर में आप हिंदी में या उड़िया में या किसी भी अपनी लोकल भाषा में आप नहीं कर सकते. कम्युनिकेशन जब किसी चीज़ का आप करते हैं तो आप एक भाषा को एक प्रयोग में लाते हैं कि इस भाषा के माध्यम से हम अपने एक्सप्रेशंस को कैसे हम लोगों को पहुंचा सकें. तो मेरे हिसाब से रीजनल लैंग्वेज या लोकल लैंग्वेज सबसे अच्छा तरीका है कि अपने को एक्सप्रेस करने का दूसरों को. I think you got the answer. Yes.
Thank you.
The next question is from Fahad Ahmad, the second year student, 3rd semester, National Law University, Odisha.
Good afternoon, honorable panel. My question is, the philosophical core of Samadhan Samaroh is the doorstep delivery of justice. However, an institutional challenge often arises post-compromise, where litigants face bureaucratic delays in the actual execution of the Lok Adalat award, especially when state instrumentalities are involved. Since a Lok Adalat award holds the finality of a civil court decree, are there specific fast-track mechanisms or compliances frameworks or administrative tracking mechanisms being established under this initiative to ensure that the Samadhan results in immediate material relief?
I think your question is based upon Section 21 of the State Legal Services Authorities Act, or
Yes.
Legal Services Authorities Act. If you look at subsection 2 of Section 21, it says is final and binding on the parties. And there is no appeal which is provided against that particular award passed by the Lok Adalat. Second thing is, it all depends upon a mindset. Can you conceptualize a thing that once the parties across the table has come to a particular settlement, can they resile or retract therefrom? I think possibly it should not be. Because it is a freedom which is already in them, whether to agree or not to agree. Once they have agreed, then what we feel is that they must honor the terms and conditions which they have agreed upon. And in order to eradicate this kind of a confusion or an apprehension in the mind of the litigants, this is the first time an initiative has been taken by the Supreme Court to request each department of the government to appoint a nodal officers. If the nodal officers are there and if the settlement has been arrived, I do not think that there will be any kind of a resile from the agreement which they have already arrived at. Though you say that it is like a decree passed by a civil court executable under Order 21 of the Code of Civil Procedure, which is again putting the entire thing into another arena, yet I believe when these initiatives have been taken for the first time, I don't think that there can be any kind of an apprehension in the mind of the litigants that it will not be honored.
Thank you, sir.
Next, Mr. Raj, the second year student, 4th semester, National Law University.
Good afternoon, sir. My name is Ashutosh Naik. I am from National Law University, Odisha. My question is that Section 18 of the Mediation Act 2023, it stipulates a time period of 120 days from the date fixed the first appearance of the mediator, and as extra 60 days of mediation approved by the court. However, an official statistic and a routine observation, we can see that the number of cases which are unsuccessful are more than the number of cases which are successful. Some parties do not have a genuine intent to compromise on this, or are very stubborn on keeping their ideals fixed. So, as per the administrative perspective or judicial perspective, what steps can we do in order to ensure that the capacity of this institution can be reserved for those cases in which mediation is successful and it is much more viable?
You are going by data than on the reality. I think every failure taught us such certain lessons, and we always take it as a further challenge to improve the system. As I already said, that so far as a mediation is a party-centric and a party autonomy is also there, the mediator does not take part into the mediation as an adjudicator. As I already in my speech have said, that he acts as a facilitator, simply facilitating or fostering the open dialogue between the parties. Now, willingness is one of the important factors. If a litigant does not think that he will settle the dispute through this mediation mechanism, there is no compulsion on him to go for a mediation. It is what is a willingness which is very important in a mediation system. Once he shows his willingness, I do not think that there is any possibility that he has come with an intent of not settling the disputes and simply wanted to delay the process. There is a timeline which is already there, and if the mediator finds that there is a possibility of any settlement, the mediator can definitely give or foster more dialogues amongst the litigating or litigating parties. And I believe that the success should not be measured on a numerical number or a percentage basis. The success should be measured that how effectively we can put a particular system in place. And I hope that the history will definitely say that how the mediation has really changed the entire legal framework in future. I believe that the day will come, and I'm very optimistic in this regard.
Thank you, sir.
next question is from Madhusmita Sahu, a third year law student, sixth semester, Madhusudan Law University.
Good afternoon, sir. My name is Madhusmita Sahu from Madhusudan Law University, Cuttack. And my question is, while ADR mechanisms are promote speedy disposal of cases, there may be a situation where the compromise does not fully protect the rights of the parties. So, how does the judiciary strike a right balance between this speedy disposal of cases or speedy dispute resolution and a constitutional commitment to justice, fairness and protection of rights of the parties?
I tell you very frankly that there may be a multiple disputes between the parties. And there is no hard and fast rule that all the disputes have to be resolved through a mediation. If the parties have agreed upon and settled some of the disputes out of many, there is no, I would say, fetter on the part of the mediator or a system that they cannot settle those. So there may be a partial settlement, amicable settlement through a mediation, and the rest that may be adjudicated by the court so far as their rights are concerned in a more, the fair, transparent manner. So I don't think so there can be any apprehension or a confusion in this regard in your mind.
Sir, is there a established judicial framework for determining which cases are better suited?
There is already, that's why I referred that case of AFCON, where the Apex Court has already says that these are the categorization of the cases which are amenable to be settled through mediations. Now the Mediation Act has also come, but it has not been put in place. It's not been enforced as of now fully. So they have also categorized that those are which are the cases which can be settled through a mediations. Not every cases. If there is a offense against the society, is a heinous crime, that cannot be settled through a mediation.
Thank you, sir.
Yes.
The next question is from Sobhagini Naik, the first year law student, second semester, Madhusudan Law University.
Good afternoon to the esteemed panelists. I am Sobhagini Naik from Madhusudan Law University, and question for today is, as ADR gains prominence, what safeguards are essential to ensure that the constitutional settlement remain both fair and informed, particularly in the situation where the parties are not placed on an equal footing?
I understand you wanted to say unequal bargain. A person who is in a dominant position and a person who is in a subservient situations, you are talking about that it will be an unfair agreement. Again, I said, madam, that so far as the mediation is concerned, it is completely controlled by the parties themselves. And if the party thinks that the terms and conditions which have been, which has been sent to him is not beneficial, or does not really come in aid to the dispute or his rights, definitely he will not be compelled to undergo with this kind of an agreement. He can definitely say that I am not agreeable to this kind of the terms and conditions, which is really having or impacting my rights, which I have claimed before the court of law. So question of unequal bargain will not done. Secondly, there is already a neutral man who is really conducting the entire mediation, the process. Is called as a mediator. So he is a trained person, he is a skilled person, and he uses various techniques and the tools where he can bring the parties to a common platform. And it is all done in a very fair and a transparent manner. Second very important facet of the mediation is that it is the confidentiality which is always maintained. And this confidentiality ensures that whatever is talked about or whatever has been deliberated upon will not be used anywhere against the parties. So that's why I think that there cannot be any apprehension in your mind regarding the unequal bargain situations. It is absolutely they are on an equal platform. I believe that answers your question.
Yes, sir. Thank you, sir.
Some DLSs and some LLDs who are connected through pieces, they may also.
As you all know, some of the secretaries of the district legal services authorities are present physically with us, and the rest of the DLSA secretaries, the panel advocates, the paralegal volunteers and the LADCs, they are joining us virtually. So similarly, some nodal officers from different departments, they are also present here. So if any of you have any kind of question regarding the procedure and or any other doubt entertained in your mind, then you are invited to ask any question to the honorable panel. Yes, please. Yes. Please give your identification.
Yes. I am Jayakshar Misra, Additional Secretary, Water Resources Department.
Works?
Water Resources. So out of 1559 cases Supreme Court listed for High Court, we have identified 41 cases of this department. One is related to finance and all, GST versus say. So we have found out 8 cases to be resolved. The principle has been decided by the Supreme Court. Besides, 8 cases are there land acquisition matters. But we found that originally at the time of acquisition of project, water resource project, it was the price was whatever as per the notification we have granted. Section 18 reference, it has been 30 times allowed. So we had been to Supreme Court in 2022. My question is that if this is in the mediation process, we can mediate and I will request the mediator, we can try if there is mutual consensus of the rate.
Exactly.
This is what is the really the motto or elixir of the mediations. The parties can definitely come to a common platform. They will not be guided by any kind of a adjudication which has already been made. So if both of them come to a consensus, I do not find there is any kind of a difficulty in this regard in arriving thereat. It may be the parties, the party may reduce that particular, the market value, and you have also agreed to increase to a certain level. So if both of them jointly, with the open mind, the consensus has arrived, that is why the Supreme Court has initiated this particular process of Samadhan Samaroh.
So in the matter we need expertise in mediator, so that they can mediate.
No, there is already mediators are there. They are acting. Either the DLSAs are already put in place. He will be doing it and identifying all these the things. And the trained mediators are there. There cannot be any problem in this regard.
Okay, thanks.
What is this problem?
Yes, thank you. Yes, thank you.
My Lord, namaskar. I am Subhankar Mishra, Secretary DLSA, Deccan. My Lord, my question is, in some cases, my Lord, on one side there are multiple persons, multiple people contesting the cases. In such cases, their interests are aligned so far as the legal result is concerned. So that is why they have gone to the Supreme Court, Honorable Supreme Court, for their redressal of their grievance. But my lord, when it comes to settlement, they may have different demands or different interests. So how a mediator can approach such a situation, my lord?
That is what the role of the mediator really comes. And that's why there is a committee of the Supreme Court which says that a mediator must undergo a 40 hours training programs. So the mediators are really being taught to use certain techniques, certain tools, and they becomes a very skilled persons. They will definitely put some kind of an impetus into the parties and act as a facilitator so that the parties can come to a common platform. If they come to a common platform, I think the mediation will be always a successful tool. Yes, please.
Look, what is the role of mediator, trained mediator? Trained mediator, role of a trained mediator is to find out what is the individual interest. There are multiple parties in a litigation. The role of the trained mediator is to find out the individual interest. They are specifically and specially trained for that. Once the interest of the party, individual party is identified, then it will be easier to facilitate mediation. Otherwise, there cannot be any mediation. So it is the role of the mediator, as my lord said, it is the role of the mediator to identify the issue and to protect the interest. The parties are there, they are at a common platform, so they can bargain themselves. The mediator only facilitates. Okay. I think you have got your answer. Thank you.
Yes.
Any other question? As we have come to the end of the session, I am now requesting Mr. Aurobindo Patnaik, the Member Secretary, Odisha State Legal Services Authority, to propose vote of thanks. Yes, Mr. Patnaik.
Namaskar and good afternoon. I feel honored and privileged to propose vote of thanks on behalf of Odisha State Legal Service Authority on successful completion of this sensitization program. First and foremost, I would like to extend our deepest gratitude to Honorable Sri Justice Harish Tandon, Chief Justice, High Court of Odisha, Patron-in-Chief, Odisha State Legal Services Authority. Your Lordship has a unique and unmatched ability to analyze information quickly and efficiently. Your deep insight on this topic practically enlightened us. My sincere thanks to Honorable Sri Justice Mahesh Ranjan Pathak, Judge, High Court of Odisha, and Executive Chairman, Odisha State Legal Services Authority, for meticulous planning of this event and for guiding us at every step. His Lordship paid attention to every detail for the success of this program. We will continue to look towards you for your guidance and further inspiration. I would like to thank Honorable Sri Justice Krishnaram Mahapatra, Judge, High Court of Odisha, and Chairman of High Court Legal Services Committee for his support. Without his Lordship's support, it would have been very difficult to organize such grand and useful program. We will seek his kind help for organizing similar program in future. I would like to thank all honorable judges of Odisha High Court for blessing us with their kind presence. I am very much thankful to Learned Registrar General and Officers of Registry, High Court of Odisha. They paid attention to every details of this program from the moment of preparation began a week back till end. Learned Director
and officers and staff of Odisha Judicial Academy for their kind support to make this event successful. Like many occasions in this past, this time they have also extended the whole support to us. We hope this will continue in future. Principal, LR and both additional secretaries of Law Department of Government of Odisha, there are hidden commandos. They did their best to help us at every critical juncture and they have become successful in most of their missions. And principal secretaries and nodal officers of these different departments of Government of Odisha, in fact, they are holding wheels of success of our vehicle of Samadhan Samaroh. Their sincere effort will help us to dispose more cases at the completion phase of Samadhan Samaroh. Secretaries, District Legal Service Authority, Cuttack, Puri, Jagatsinghpur, Anugul, Dhenkanal, for attending this program physically. Learned faculty members and law students of premier law institutions of our state like National Law University Odisha, Madhusudan Law University Cuttack, PG Department, Law Utkal University, Bani Bihar, Law Department, BJP Autonomous College and University Law College, Bhubaneswar. In fact, law students, those are present here, displayed a gold standard of discipline and very patiently they heard us. Such discipline will give them success in every future, in every sphere of their life and future. Learned Secretary, District Legal Service Authority, panel lawyers, legal and defense counsels, and paralegal volunteers of all districts of our state who have joined us virtually to make this program successful. I convey my special thanks to Additional Chief Secretary, Director, INPR Department for giving support for this program, as well as for wide circulation for the event of Samadhan Samaroh. So also special thanks to Doordarshan and their crew. They gave Odisha Legal Service Authority a thrilling experience about the direct telecast in Doordarshan. On this occasion, we also thank members of print and electronic media. Our heartfelt thanks to all of other well-wishers who have directly or indirectly helped us to make this event successful. Thank you and namaskar.
Chief Justice Harish Tandon sir, my Lord Honorable C. Justice Manas Ranjan Pathak sir, my Lord Honorable C. Justice K.R. Mahapatra sir, and Honorable Judges of the dais, my colleagues, secretaries, directors sir, in charge Vice Chancellor Rangin sir, and DLSA Secretary, and lovable students, those who are present today in this gathering. In the first opening line, my sister, Registrar General, said, litigation divides, Samadhan unites. That is what the theme of this today, the program. And as instructed my Honorable Justice Pathak sir, that I convey our thanks, sincere thanks to our nodal officers, and any one of you having any sort of doubts, feel free to contact our SALSA, Member Secretary, Deputy Secretary, or any doubt from our departments. There are 42 departments in our government, and we are liaising with all the secretaries, so they are free to contact us. This is what I am instructed to convey you all. And I once again thanks all of you for participating, and I feel proud to be present in this August gathering. Thank you, my lord.
Thank you, Mr. Saman. Let us move forward with renewed commitment to transform litigation into resolution and ensure justice reaches every citizen in its truest sense. I am confident that the deliberations today, guided by the wisdom of honorable judges, will inspire all of us to actively contribute to this noble endeavor. May I now seek the kind permission of Honorable Chair to close the proceeding?
Yes.
Thank you, Lordship. The proceeding is declared as concluded. I request Honorable Judges, the dignitaries, and all the participants to join us for lunch. Thank you all and Namaskar.